thank you very much for being here. This is the third of the UK panels where we've been looking at ending sex falsification, restoring safeguarding, highlighting the UK WDI campaign that we started around Christmas time. And we're now going to listen to our campaign explained, expanded on the laws around it, and how we believe it could be implemented. We know it maybe is aspirational, but hey, it has to be there. We have to have a line in the sand to say this is what we believe. Gender needs to come out. It's an absolutely ridiculous concept that laws should not be made on. And yeah, so I'm going to pass it over to Maureen and Sally, who are going to take us through the next set of our three panels looking at this. Thank you very much.
Can everybody hear me?
Yeah.
If I start talking fast, you just tell me, because I sometimes do that. So, as Bernadette said, WDI UK is running a campaign called End Sex Falsification, Restore Safeguarding. And by sex falsification, we mean any type of recognition of gender identity in law, or policy as well. So we started the campaign a while ago. We think the only way to fully restore safeguarding of women, children, and other vulnerable groups is by ending sex falsification in all its forms. And that would involve removing the concept of gender reassignment and of gender identity completely from law and policy. Now, as everybody here probably knows, our advocacy is based on the Women's Declaration on Sex-Based Rights. And that reaffirms that the rights of women, which are set out in the UN Convention on the elimination of all forms of discrimination against women, the CEDAW, are sex-based. Although UN Women now saying differently, but that was the original meaning of the CEDAW. And the Declaration emphasises that, and it's founded on the view that replacing the category of sex with the category of gender or gender identity or any of those similar terms, in practice discriminates against women and girls because it enables men to claim that they're women in whatever form they do it. And the idea that's incorporated into current law, into policy and into practice, and the practice in the last 10 years or so has become as important in many ways as the law. In fact, it's gone much further than the law has gone. That men can become women, at least for some purposes, everybody here I'm sure agrees, is a fiction, which undermines the safety of women, of children, and other vulnerable groups. In the UK, that fiction is supported by legislation as well as policy and practice. It's supported by the operation of the Gender Recognition Act 2004, by the concept of gender reassignment in the Equality Act, and Northern Irish equality legislation, which is very similar, or Northern Irish Order, which is very similar, and by the practice of self-declaration or self-ID, which is now very widespread in the public sector and in the private in the UK. It's not written into law anywhere in the UK, but it's been used, in fact, across a range of different sectors without any public consultation or any assessment of risks involved for women, for children, for vulnerable groups. And to fully restore safeguarding, what WDI UK is arguing is that we need to change law and policy in all of these areas. Repeal the Gender Recognition Act, but not just repeal the Gender Recognition Act. Remove the protected characteristic of gender reassignment. I'll say a little bit more about what we're going to suggest as a way of, we're not suggesting that people who believe themselves to be trans should receive no protection from certain kinds of discrimination, but we're suggesting that it can be done in a different way without recognising gender reassignment in law, and I'll talk about that. I'm going to talk briefly about the legal provisions which underpin the recognition of gender in law, just in case anybody isn't familiar with them. I know a lot of people here will be, or a lot of women here will be, I should say. The Gender Recognition Act, as I'm sure most people know, allows individuals who meet certain criteria to obtain a gender recognition certificate, which gives them what is called an acquired gender. Sometimes the act says sex, sometimes it says gender. And that acquired gender is recognised for legal purposes, which is some purposes, but not all purposes. The Supreme Court called this certified sex in the recent judgment in April, to distinguish it from biological sex. So if you have a gender recognition certificate in law, if a man has a gender recognition certificate, for some purposes, he will be treated as a woman. The Equality Act, which applies in England and Wales and in Scotland, but not in Northern Ireland, has certain protected characteristics. They're intended to protect people from discrimination and harassment. One of them is gender reassignment. And how that's defined is it applies to a person who is proposing to undergo, is undergoing, or has undergone a process or part of a process for the purpose of reassigning the person's sex by changing physiological or other attributes of sex. In fact, it doesn't require any physical changes whatsoever. The Act doesn't apply in Northern Ireland, but there's something called the Sex Discrimination Northern Ireland Order, 1976, which has essentially the same effect as the Equality Act in this country. Neither of them change a person's gender in law in the way that the Gender Recognition Act does. They never have done, although a lot of confusion has been created about that by organisations like Stonewall, etc., over the last, say, 15 to 20 years. Gender reassignment does not mean that a man who's deemed to have the protected characteristic is in any way treated as a woman in law. And it never has meant that, although that's been misrepresented. So a man with a protected characteristic of gender reassignment is just someone who dresses like a woman or in other ways claims to have a female gender. There are other protected characteristics in the Act, and I'll say what they are because I'm going to talk about some of them in relation to what we're proposing. So they're sex, sexual orientation, age, disability, marriage and civil partnership, race, and religion or belief. And the Equality Act 2010 allows for certain services and facilities to be provided on a single-sex basis, which completely exclude members of the other sex, provided that pursues a legitimate aim and does so in a proportionate way. So the basic provision there is that women-only services and spaces can be set up if there's a legitimate aim for doing that, and it's done in a proportionate way. And the Act sets out certain exceptions which allow for sex segregation effectively. Now, there's been a debate and a lot of confusion for a long time about whether those single-sex spaces in law have to include, if they're women-only spaces, have to include men who claim to be trans, or whether or not they have a GRC, or whether it needs to include them if they do have a GRC, because for some purposes they're legally female. And as everyone knows now, I think in April this year, the Supreme Court clarified that single-sex services for women do not have to include men, whether they have a gender recognition certificate or not. The Supreme Court clarified that the words woman, man, and sex in the Equality Act refer to biological sex, and that a person's sex for the purposes of the Equality Act isn't modified by the possession of a gender recognition certificate. That decision clarified the existing law. It hasn't changed the law. It's clarified what the law is and always has been. But there's been a lot of confusion about that and disagreement about it, and a lot of confusion about the interaction between the Gender Recognition Act and the Equality Act for many years. Some of that confusion comes about because of simply this area of law is confusing for people. There's a lot of ambiguity in it. But also the confusion has come about because the law was misrepresented for many years by lobbying organisations such as Stonewall, who carried out a lot of training for a lot of public sector bodies, a lot of private sector organisations, misrepresented the Equality Act, and left people with the impression that to not allow males into single-sex women's spaces was discrimination under the Equality Act. It isn't, and it never was, as far as the law is concerned. And the Supreme Court has now clarified that. So it's now clear that organisations can exclude men who say that they're transgender from women-only spaces and services, whether or not they have the certified sex of under the GRC. They can be excluded. And that the decision also clarified that lesbians can form lesbian-only associations which exclude men who claim to be lesbians. If Forum in Scotland had lost that case, that would not have been the case. There would have been certain associations where lesbians would not have been able to exclude men from lesbian-only spaces. With this decision, it's very clear that lesbians can, and even if a man has a GRC and says he's a lesbian, he cannot be, women can exclude him from single-sex spaces, and organisations running those single-sex spaces can exclude him. So following the Supreme Court's decision, organisations which are operating policies allowing people to use facilities which are meant to be single-sex, but where they're allowing people to use them on the basis that they claim to be trans, will have to review those policies and amend them. As already been talked about this morning, a lot of organisations are resisting that. Some organisations are openly saying that they're going to continue to include what they call trans women in women's spaces. They're basically saying they're going to ignore the Supreme Court judgment. They're saying the Supreme Court judgment isn't clear. They need to wait for the Equality and Human Rights Commission to clarify it and so on. It's very clear, very, very clear legal. As legal judgments go, it's unusually clear, in fact. Doesn't need clarifying. They know what it means, but they just are resisting it. So it's a very important judgment. It's a major step forward. I think we need to go a lot further in challenging the harms that are being caused to women and girls in particular by the ideology of gender identity, which allows men to falsify their sex. The Supreme Court judgment won't solve that completely, and I'll give some examples of why not. And the reason why it won't is because there are still situations where men will claim to have a female gender identity, and that is going to where that is harmful to women, to children, and also sometimes harmful to vulnerable adults as well. I mentioned the CEDAW earlier. The CEDAW recognises the power imbalances between men and women which cut across society as a whole. It's meant to try to rectify that. And the Declaration recognises that in the context of these power imbalances, enabling men to falsify their sex discriminates against women and girls, as I've said, and it undermines our safety and dignity and privacy. And as we all know, a central aspect of the power imbalances between men and women is men's violence against women and girls. Crime data everywhere shows that sex is the most significant factor shaping criminal behaviour, especially in relation to sexual offences and violent offences, which are overwhelmingly committed by males in any part of the world, including the UK. The Ministry of Justice, which produces figures on England and Wales, they published data in 2020 that showed that 98% of those prosecuted for sexual offences in 2019 had been men. And that figure, 97, 98%, appears in lots of different research studies. In 2021, the crime survey for England and Wales showed that between March 2017 and March 2020, the majority of victims who had experienced rape since they were 16 years old reported that the perpetrators were male. And there's a similar pattern in relation to sexual assaults against children. In a 2019 crime survey, England and Wales study, 92% of respondents to the questions who'd been sexually abused in childhood said the abuse had been perpetrated exclusively by males. Other types of violence as well, the figures are very similar, not just sexual violence, but physical violence also. And to give you an idea of the difference in criminality between men and women, men are 95% of the prison population, roughly each year. Women are 5%. The prison population. And crime data shows that men who claim to be women often retain male patterns of criminality. And information about the prison population, for example, shows that the proportion of male prisoners claiming to be women who've been convicted of sexual offences is higher, much higher, than the proportion of convicted sex offenders in the general male prison population. And there's lots of different figures, but I think some of the clearer figures were produced in the case of Crown on the application of FDJ and Secretary of State for Justice, which was the case which was brought to try to remove men completely from women's prisons. The case didn't succeed, but they produced figures which showed that 49.7% of trans-identifying male prisoners were serving sentences for sexual offences in 2020, as compared to less than 20% of the general male prison population. Now, those figures might not be replicated in the general population, those proportions, we don't know that, but it's certainly what they do show is that not only do men who claim to be women not lose male criminal patterns, they may have, be more inclined towards committing sexual offences often than other men are. So that has ramifications in terms of sex falsification, as we all know. It undermines safeguarding for women and girls from male violence. It has been eroding the provision of single-sex services and spaces and putting the safety and the privacy and dignity of women, children and vulnerable adults at risk in all sorts of contexts. Men have been gaining access to provisions designated as women only, such as domestic abuse refuges, rape crisis centres, hospital wards, prisons, public toilets and changing rooms. Men who claim to be women have been designated to carry out intimate care of women who are ill, who are disabled. Male participation in many female sports has been putting girls and women at physical risk and forcing them to change and shower in the presence of males. And that's aside from the fact that women are losing sports prizes and losing races and so on, which they would have won if a male wasn't competing against them. The Supreme Court's ruling will help to reduce these practices. I think it's going to take a battle, though. They're not going to willingly stop a lot of the organisations that are running so-called single-sex spaces, which are in fact mixed because they include men who claim that they're trans. They've made it very clear, a lot of them, that they're not going to easily change those practices. But the Supreme Court ruling should allow us to pressurise them to do that. But there are other aspects of law and policy which continue to validate sex falsification, which still needs to be reformed. So within the criminal justice system, data recording about suspects and offenders is often based on gender identity rather than sex. The Supreme Court ruling gives a lever which can be used to try to change that, but it won't automatically change it. That leads to inaccurate criminal justice statistics. And in the UK, anyone can change their name and sex markers on documents used for identity purposes, such as passports and driving licenses. That's been the case for decades. And those documents can be presented for the purposes of criminal record checks. which makes those criminal record checks unreliable. And that means that in some cases, sex offenders and other violent offenders can hide behind a different identity, which puts women and children at risk. Men are still being placed in women's prisons. That's subject to risk assessment. Prison searching policies in England and Wales and in Scotland require female prison officers to carry out intimate searches of male prisoners who hold a gender recognition certificate unless the men involved agree otherwise. That includes men who are sex offenders. A lot of them are sex offenders. Those policies obviously undermine the safety, dignity and privacy of, in the case of placement of men in women's prisons, of women prisoners. In the case of searching policy, it undermines the safety and dignity and privacy of women prison officers. It potentially breaches their right under Article 3 of the European Convention on Human Rights, which prohibits inhuman and degrading treatment. I think it's clearly degrading treatment to force a woman prison officer to intimately search a male. And it can potentially breach their rights under Article 8, which is the right to privacy as well. There hasn't been a challenge yet. Maybe there will be, I don't know. It remains to be seen whether the prison service will review their placement policies and their searching policies following the Supreme Court judgment. We don't know that yet. Making all prisons single sex could easily be achieved. In fact, it could have been achieved before the Supreme Court judgment if there was a political will to do it. Maybe there will be more of a political will now, given the judgment. That remains to be seen. But if male prisoners who have a GRC, if there was a policy saying that they had to be searched by men, they would have a potential claim under the European Convention on Human Rights that they are being subjected to inhuman and degrading treatment because for some legal purposes, they're female. So they can argue, well, it's degrading for me as a woman to be searched by a man. Whether they would succeed in that, I don't know, but they do certainly have a potential claim, and they have a potential claim that their rights to privacy under Article 8 are being breached as well. Which is one of the reasons why we need to get rid of the GRA, because it does give men claiming to be women some additional rights, even with the Supreme Court judgment. In response to the Supreme Court's judgment, the police in England and Wales have reviewed a policy which they were bringing into place, which allowed trans-identifying males to search female detainees. But they haven't fully introduced same-sex searching policies. Recently, the National Police Chiefs Council published a draft interim guidance which says that when the police carry out what they call thorough searches, and those are ones which expose intimate body parts, they should be carried out usually by police officers and staff of the same sex as the detainee. But it also says that with limited exceptions, it may be possible where someone requests it to be searched by a person of the same gender. So basically that would be, in most cases, that would be a trans-identified male saying they want to be searched by a woman. And they said that will be allowed with the written consent of the detainee and the officer carrying out the search and the senior officer who would be supervising the search. Sex Matters have been challenging police searching policies, and they brought a claim against the British Transport Police for that policy of allowing men who identify as trans to search women. And for that, they submitted evidence based on interviews with female police officers, and they asked them about this giving their consent to searching males who say they're trans. And they said essentially that in a male-dominated and hierarchical environment such as policing, it would be very difficult for them to refuse a request to strip search a so-called trans woman. And they said they would feel humiliated by doing that and degraded. But despite that, it would be difficult to refuse. I think that you probably need to actually do research to work out that it's virtually impossible. It's going to be impossible for female prison officers, policewomen, to refuse if a senior officer has put pressure on them to do it, even if technically they're consenting to it. And they said a request by someone of the same gender. So it seems it won't depend on the GRC, it will depend on how this person self-defines. Now that policy could remain in place despite the Supreme Court judgment, if that's what they finally introduce. The Supreme Court judgment should lead to the removal of NHS guidance on so-called same-sex accommodation, which in fact includes men who identify as trans. They're allowed to be on women's wards and to use women's toilets and bathing facilities in hospitals, quite explicitly under NHS guidance. That should be changed. I think after the Supreme Court judgment, it remains to be seen what the NHS will do about it. But even if that's the case, it won't automatically lead to changes in data protection practices, which record patients and clinicians on the basis of their claimed gender rather than their sex. And that's despite the fact that recognition of sex is crucial to many aspects of medical diagnosis and treatment. Obviously it is. There have been cases, certainly in the States, I'm not sure, I think there might have been one here as well, where women who identify as trans men, because they've been treated by clinicians as if they were really men, those clinicians have missed important symptoms, and that's led to serious illness, and I think in one case led to death. Because they just, yes, this is a man, so we'll pretend this is a man, and some of them might have even thought that the women concerned were men. I think women who've been on testosterone for a long time, at least superficially, are more convincing as the opposite sex than men who take female hormones. I think, anyway, people seem to be more easily fooled by it. In relation to children, the physical and mental health of children and young people who are deemed to be transgender has been put at risk by the use of puberty blockers and then the use of cross-sex hormones. Now, that's changing with the implementation of the CAS review, but the widespread influence of the concept of gender identity within public institutions is still creating safeguarding risks for children and young people. Now, the new guidance for RSE, relationships and sex education, has talked about not teaching gender identity theory as if it were fact, but it can still be taught. And children can still be taught that there are children and adults who believe themselves to change their sex. So the idea can still be put in children's heads that it's possible to change sex. And more than that, depending on whether the teachers are activists or not, who are pro-trans or pro-transgenderism. And the Supreme Court judgment isn't going to change that. It will probably bring an end, or it might bring an end to the practice of allowing children who are categorised as transgender to use the toilets and changing facilities of the other sex and share accommodation with children of the other sex on school trips, which is very obvious safeguarding risks. We'll see, we don't know. And judging from what Tanya was saying this morning about schools, if that change comes about, I think it's going to be a long time coming about as a result of the Supreme Court judgment. So as long as the fiction that people can change sex continues, women, children, and vulnerable groups will be at risk. The Supreme Court judgment mitigates those risks, but it won't completely remove them. And I don't think they will ever be completely removed unless the whole idea of gender identity as a reality, as something that's real, is completely removed from law and policy. People may believe they have a gender identity that's different than their sex. You can't change people's beliefs about that, but you can have law and policy which says society is not going to act on this. The law is not going to recognise this. Policy is not going to recognise this. You can think whatever you want to think about yourself, but we're not going to go along with you. Okay, I'll just go on to what we're proposing. So we're proposing repeal of the Gender Recognition Act. Some legal academics, and I think they're right, Michael Foran is one, has argued that if the GRA is removed, things could be made worse because judges, in order to put into effect the decision-making of the European Court of Human Rights, may introduce, through case law, even more damaging provisions than the Gender Recognition Act. People forget, I think, that even before the Gender Recognition Act existed, it's a result of judges' decision making that men were placed in women's prisons. Nothing to do with the Gender Recognition Act. Judges decided it on the basis of the European Convention, Article 8 rights, private life. So we're saying, yes, the GRA needs to be repealed. In and of itself, that won't make things better. It could potentially make things worse if everything else is removed as well. So we're arguing that that's one of the reasons we're arguing for the removal of the protected characteristic of gender reassignment. And what we're saying is that could be people who subjectively identify as transgender could still be protected from discrimination in things like housing, for example, in certain types of employment, by one of the other protected characteristics. Alessandra Astoriti has talked about that. She's talked about 3 different characteristics that could be used. I think the most important one is the one of belief. So people could be protected on the basis that they believe that they have a transgender identity from certain types of discrimination. But having said that, I think that if we are going to introduce a different type of protection other than gender reassignment, that has to be done in a way which recognises that some individuals' manifestation of their gender identity is based on a paraphilia, like autogynephilia, one of the other paraphilias, and that is a safeguarding risk for children and vulnerable adults especially. And so if people were protected from certain types of discrimination on the basis of their having a belief that they have a transgender identity, I don't, for example, that should stop them being able to get housing. So they could be protected from housing discrimination, different types of discrimination. But in the context of employment, it needs to become possible to assess the risk of men with paraphilias, whether that be autogynephilia or any other paraphilia, in regard to the way in which they violate other people's boundaries. Now, Tanya said this morning that they shouldn't be in schools. I agree with her. Whether we could actually introduce that, I don't know, but one of the things we could at least work towards is assessing the risk of people with paraphilias around vulnerable groups and reaching a conclusion.
It should already be there.
I agree.
No, if people, safer recruitment's there, if people followed safer recruitment, they would never have been allowed into the school.
That's absolutely right. Would you let Maureen finish, because there'll be time for discussion afterwards. So I think it's,
I've run out of time.
Okay.
I think I'll stop then. I was going to talk a little bit about if we did repeal the GRA, what would that mean for the UK status as a party to the European Convention? It's going to create problems in relation to that. But we could talk about that in the discussion if anyone's interested in talking more about that. So I'll stop there because I've run out of time anyway. Thank you.
Thank you very much, Maureen.